I had a client who is facing eviction under Ground 8 of the Housing Act. Now, Ground 8 is a mandatory ground, which means if it's met, the judge has to award possession. The client had said to me that he had the means, he just needed time. So I made this representation to the judge. The judge agreed to a 2-hour adjournment to test this tenant's theory, at which point the tenant told me that whilst he did have the funds available, it was in the form of a cash loan from his family, which he'd need to collect, deposit in his bank, and make the transfer on before the resumption of the hearing. We only had 2 hours. He also told me that he hadn't brought his bank card to court, and so he'd have no way to even deposit the cash, even if he had the cash. Faced with the clock ticking and the fact that this tenant did not have the means to purchase a taxi, I offered him a lift on my bicycle such that we could take him to his house to pick up his bank card. We then cycled our way to Halifax Bank on Commercial Road, Portsmouth, where we met his brother. We took the cash, it was about $2,000, deposited it in Halifax. He then made the bank transfer using his mobile app to the landlord, thereby reducing the amount of arrears below the mandatory 2-month threshold. We then returned to court, receipt of transfer in hand. I made the representation to the judge that we were no longer in the 2-month threshold, at which point the judge agreed to a suspended possession order as opposed to an outright possession order, which was a distinct victory for the client because it was a complete reversal of where he was just 2 hours ago. And I'm proud of that instance because I went above and beyond for my client.
Hi everyone, I'm Tom, Chartered Architect, Designer, Builder and Property Consultant. Welcome to episode 2 of Property Enlightenment. Today we're going to be talking about the world of law. We're going to be talking about tenants, we're talking about tenants' rights, and we're also going to touch obviously on my favorite phrase, property enlightenment. We hope to be able to delve into some of the latest developments in the world of legislation, as well as what changes are coming through that will be beneficial for tenants, and then how that's going to link to standards as well. Housing standards, which you know that I'm keen on. Okay, so let's get into it. I'm here today with my friend Peter Jacobs, who's an aspiring barrister studying with King's College in London. And obviously we have been introduced through a mutual friend, someone that is dear to both of us. So Peter, welcome. How are you doing?
I'm doing well, thank you. Thank you for having me.
Really glad that you could join us today. So if you could tell us a little bit more about your background. So I understand that you've studied a number of different universities, you've covered a number of different subjects, but you've come to aspire to be a criminal barrister. And as part of your experience in the world of law, you've actually worked for the Wiltshire Law Centre, and you've actually represented tenants in county court. And you have managed to represent them against landlords, among other things. So please give us a kind of brief spin around the situation.
I studied history and politics originally in York. I then did a master's in international relations, which led me to live in Germany and then in the Netherlands. I then moved to London, did a law conversion course, worked as a paralegal, a criminal defense paralegal for some time. I then shifted to work as a housing caseworker for the Wiltshire Law Centre, and in that role I represented tenants in county court possession proceedings. Following that role, I started my studies to be a barrister. I'm hoping to be called in January next year. But yeah, delighted to be here to discuss all matters housing.
Oh, that's fascinating. So thanks so much for sharing that. I understand as well that you have been a barrister in residence at the University of Portsmouth as well.
The idea is at the University of Portsmouth to have 5 barristers in residence, people who can inspire law students at the University of Portsmouth that they too can become barristers. The other barristers in residence actually qualified barristers. I represent the student pathway, so I'm on the way to being a barrister, and that's my role.
Okay. No, thanks for clarifying that situation. I think it's really interesting. So you've obviously covered a lot of different areas in your career, and I think it's good. That enriches things, as then you obviously can bring in anecdotes and we can get into the kind of horror stories, the good, the bad, and the ugly, which I always like to cover in these sessions. So you're very welcome. Thanks so much for joining us. So we're sat here today in a very nice studio, but I do like to start every discussion with this topic, which is to ask what has been your experience with property, both in your professional and in your personal experience, living and working in the UK. And then I understand you've also been in the Netherlands and in Germany as well. And it would be very interesting to hear your kind of stories in terms of the good, the bad, and the ugly.
So, when it comes to horror stories that I'm sure your audience will be delighted to hear of, I'd say these have come up mostly in my work representing tenants. You know, I've seen quite desperate scenarios that people find themselves in with rogue landlords. You know, your classic boogeyman rogue landlords. My own experience of housing, both here, both in Europe, has actually been largely positive. Mostly I've had good relations with my landlords. They've been fairly responsive. I'll go through a bit of a laundry list, if you like, of the experiences I've had. So say in York, I had 2 private rented properties that I was living in, one on Tang Hall Lane, which was a bit of a rundown place, but the landlord was responsive enough. It was a classically dirty student house, I'd say, in the sense that
I think everyone's been there though, right?
Well, if you were to walk around the kitchen and the dining room in this house, your feet would turn black. Okay, so I wonder if everyone's been there. What else could I point to? I lived in a converted stable in my 3rd year in York, which was actually a delight. It was just by the River Ouse next to Millennium Bridge. However, the negatives of this apartment were the low ceilings, and as a tall man, having to constantly duck, you know, wasn't ideal for posture. Did bang my head several times. I wonder if that is hurting my career aspirations at this point.
Hopefully not.
Moving on, following my time in York, I was attempting to traverse the German housing market when I moved there for my master's. I quite naively moved out to a place called Weimar, which you'll know from the Weimar Republic era, and I booked myself in to stay in a hostel for 3 days, and I thought in that time, surely I'd be able to find an apartment to live in either Weimar or Jena, which was my university town. However, I was completely wrong. Of course, it took a lot longer to acclimatize, so I ended up spending 3 weeks sleeping on the floor of a friend of the international student mentor that had been assigned to me. Right. And this friend was so kind to me and just let me stay on his bedroom floor for these 3 weeks whilst I tried to find my own place. I eventually did. I moved into a typically East German named street called Karl Marx Alley, where I stayed in an apartment with a nice guy called Kang, and then another guy who I never met, never knew the name of. He would move in the shadows. He would fill the fridge with packets and packets of meat. And it was quite scary to live with him, actually, because I really had no idea what he was about. But he was big, physically quite big and imposing. So I was only there for a short time. That was a sublet. I then moved to Weimar, where I lived in student accommodation, which was actually a brand new build. It was called Jakobsplan. And that was, the facilities were pretty decent there, actually. Can't complain. Reasonable rent, I think €450 a month.
So better than the UK then? Better
than the UK. And I was able to pay that rent through doing night shifts a couple nights a week at a hotel in Weimar. Wow. In between my studies. Okay, so leaving Germany, I then moved to the Netherlands. Stayed with a friend briefly in Leiden. I then found a sublet of my own in The Hague, which worked out grand. That was, again, €450 a month, and it was a lovely location. Big fan of The Hague. But I wasn't a formal tenant, okay? And that's something of a theme of my housing experience. I've had to get by with sublet situations, and I think some of your audience will be able to relate to that, which has meant I haven't had the rights of a tenant, which I think are quite significant and I've learned that through my work as well. I had this sublet in The Hague. I then moved back to Germany, to Leipzig, where I had another sublet for a few months. I then returned back to The Hague for a library job I took on. And again, I was in a sublet situation, living with an elderly lady, dear Bertie De Bruyne. I then left the Netherlands. I moved to London to commence the law conversion course. I spent 3 months living in Far East London, Woolwich, where I was staying with a Franco-Russian family of a friend of mine that I'd met in The Hague. And they had two young girls, so I could only stay so long, really, but I'm grateful to them for having me. I then swapped Woolwich for Chelsea, staying with a childhood friend of my mum's on his top floor. Again, no formal tenancy agreement. I paid my rent in cash, which I'd put into a little cash book that he kept in his basement, where his cleaners would then take their wages out of the rent money that I'd put into this cash book. That lasted about 9 months. Some good times, some less good times. I then switched that for the sitting room floor of my friend's house in Kennington, where I lived for 3 months before moving out, commencing my job at the Wiltshire Law Centre, which led me to move back in with my parents in Portsmouth to a vicarage. And most recently, I've moved back to London in early March. And finally, after this whole journey that I've laid out, I have a tenancy agreement of my own. And I'm enjoying the freedom that brings, the liberty you feel to be able to invite people back to your place, the liberty you feel to approach your landlords for complaints or for redress. It's an entirely different living experience to being at the behest of whoever is subletting out to you, I think.
No, I mean, that's quite the journey. I mean, I can picture it each and every stage. I've been in some of those kind of situations, those sublet situations myself as well. I understand the kind of uncertainty that comes with that. And obviously, I think then we can get into some of that detail today. We're going to talk about tenants' rights. We're going to talk about property law, and we're going to talk about some of the recent legislation that's coming out, and I hope to get into that as well. I think it would be good to see how that's going to improve the situation for people, and also we can try to address what's missing as well. If we're going to try and aspire towards an enlightened state of property, what is the additional legislation, the additional kind of ideas and policy that could be required to take us there? So I'm looking forward to getting into that. But thanks so much for sharing those very much emotional roller coaster of a start into the world of property. All right, next question. What has been your experience representing clients and tenants in courts of law? And again, your experiences of case law and of the good, the bad, and the ugly. I'm sure you've seen some very interesting scenarios and some very harrowing ones as well that people will have suffered from. So I'm very interested to hear your experiences there in the work that you've done with the Wiltshire Law Centre, and then also potentially with your barrister in residence work at the University of Portsmouth.
I should say that I was working as a housing caseworker for the Wiltshire Law Centre, and the Wiltshire Law Centre runs according to a civil legal aid contract, which gives it the right to assist people pretty much in any housing legal situation, should they qualify according to the legal aid means assessment. However, I'd say my court exposure in this role came in my capacity as an acting duty solicitor, which I undertook in county courts in southwest England. Places like Aldershot, Basingstoke, Southampton, Portsmouth, Guildford once as well. Now, when it comes to the duty solicitor scheme, this is funded under civil legal aid as mentioned, but it's called the Housing Loss Prevention Advice Service. And what's a bit different about this in terms of finance is that actually there's no means assessment. So if you, audience, are facing a possession matter, your landlord's trying to kick you out of your property using legal means, you have the right to contest that, and you have the right for that to be heard in a county court. And what's more, under this advice service that I mentioned, you have the right to free legal representation in that possession hearing. Okay, and so the way it will work is that you'll show up to court. Hopefully, you'll bring paperwork with you, which has your tenancy agreement, which has the particulars of claim and the claim form that's been brought against you. You'll present this to your duty advisor. They'll scour through the paperwork you've put before them, and hopefully, sometimes, they'll be able to identify a viable defence as to why actually this possession attempt that is being brought against you is being done so illegitimately, perhaps unlawfully. Perhaps there's a procedural defence that can be identified. Sometimes there's a more substantive defence as well, for example, under the Equality Act, that could make this possession attempt unlawful. So, to go into some of the examples of tenants that I represented, and I should say I always represented defendants in these proceedings, so you'd never have found me representing landlords. Not so much a political thing, that's just the way the Wiltshire Law Centre operates. So, a few case studies to bring in. Now, I'll start by talking about the Section 21 procedure, because I think this will be relevant later to the discussion also. Section 21 might be familiar to some of the audience. This is Section 21 of the 1980 Housing Act. And under this procedure, soon to be abolished, landlords have had the right to evict tenants where there is no blemish on that tenant's record whatsoever. That tenant has been reliable with their rent. There's been no antisocial behaviour. There's been no violation of the tenancy agreement. This is a first-class tenant we may be talking about. However, the landlord, for whatever reason, perhaps they want to sell the property, perhaps they are disgruntled with the tenant for unaccountable reasons. Regardless, the landlord, under this Section 21 procedure, has had the right to evict that tenant, provided they comply with all the technicalities as to how this Section 21 notice is served. Yes, they have the right to the Section 21 procedure. Where the landlord has fully complied with the Section 21 procedure in the way of providing gas safety certificates in good time, energy performance certificates, how to rent agreements in time, as well as adhering to due notice periods, where the landlord's done that, the judge has had no discretion but to award the possession in the landlord's favour. Mm-hmm. Okay? So, actually, as long as the landlord has dotted the I's and crossed the T's, perhaps through legal advice they've sought, or perhaps through their own diligence, the tenant has been unable at all to resist this possession attempt. Which, audience member, you may think is unjust, and we'll come on to that later. So, I did have... I'll give you two examples relating to Section 21. One where I was able to successfully resist that possession attempt, and one where I wasn't. So the one where I was able to resist the possession attempt, I'm quite proud of this instance, and I brought it up in legal interviews, and I'm proud because I thought it brought together a lot of the skill set that you actually need to be a good barrister, and this is why. So the client arrived at court. They were in decent spirits. They weren't a hot mess, as sometimes clients were. However, they were quite animated.
Understandably,
but they were animated in the sense that they were convinced that the possession attempt that was being done against them was illegitimate. That they had a defence to it. And so they were talking very quickly at me, and it's just me and this client in a small conference room, and they're spilling all the beans and I'm trying to catch the beans and see which one will be useful. But actually, the way I was able to do that was less through what the client was saying and more through surveying the paperwork he'd put in front of me, which was thick in nature, okay? I went through this paperwork and I realized that actually this Section 21 attempt was being done within the first 4 months of the tenancy, okay? Which violated Section 21 of the Housing Act, because under that provision, you have to wait at least beyond the first 4 months of the tenancy. And so I was like, hallelujah, this is an ironclad defense. The landlord has nothing to stand on. This will be thrown out of court. I went into Aldershot County Court, spoke with the district judge, who was, I think, herself delighted, because delighted in the sense that this was an open shut case. When the landlord does not fully comply with all of the procedural technicalities, the Section 21 procedure will just not go through. So we were able to very quickly close the case, and the landlord's protestations fell on deaf ears. And this gentleman, my client, was very grateful to me. In the conference room afterwards, he was bowing down to me in this motion, genuinely. So that was a successful resistance I was able to do to a Section 21.
And it didn't actually go to full court. It was settled with the judge prior to the trial?
No, it didn't go to full court, you might say, but it also wasn't a private settlement with the judge. I was in the county court in front of the district judge. The claimant was there also. We made our submissions to the judge, and the judge took my submission forward, that it was an illegitimate Section 21 claim. Okay. Now, an instance of where my attempt to resist the Section 21 failed would be Southampton County Court. And in this instance, the Section 21 paperwork requirements that I mentioned previously had been complied with. It had been done so in good time, so not within the first 4 months of the tenancy. However, speaking to the clients before the hearing, I thought there could be a retaliatory eviction defense. Now, to explain what that means, whilst it is the case, almost always, that if the landlord has complied with the paperwork requirements, they will be able to get possession through the Section 21 procedure, there is a line of defence that tenants can take where they can show that this is a retaliatory eviction attempt. What that means is that it has not been lawful for landlords to respond to tenant complaints as to disrepair in the property by electing to evict them using the no-fault regime, okay? However, there's technicalities within that, okay? It can't simply be that a tenant has reported disrepair to the landlord and they have then decided to evict them under Section 21. That is actually a legitimate no-fault eviction attempt, okay? Mm-hmm. However, suppose there was disrepair in the property and the tenant then reported this to the local authority, who then in turn served an improvement notice on the landlord, okay? And the landlord then responded to this improvement notice by serving a Section 21 eviction attempt. That would be an ironclad example of a retaliatory eviction attempt, okay? So in other words, it's not good enough for the tenant to complain, okay? They need to take that complaint to the local authority to get the improvement notice in order to be protected under Section 21, okay? Sorry if it's a bit granular.
Yeah.
Now, in this instance, the tenants had really, I think, complied as far as is reasonable with what would be expected of a tenant, in that they'd initially reported the disrepair to the landlord. That had fallen on deaf ears, so they'd reported disrepair to the local authority. However, the local authority, for whatever reason, had not served an improvement notice on the landlord, okay? And because of that failure by the local authority, this retaliatory eviction defence was not available to tenants in this instance, which I thought was deeply unfair. But that just shows to you something of the brutality of the no-fault eviction regime, Because in this case, the tenants really did all that could be expected of them. It was the local authorities' misstep that meant the procedural defence was not available to the tenants. So in that case, the possession went through, and these honourable, I would say, tenants were, I would say, unfairly evicted from their property. Now, just to bring in any questions, or I can
I
keep
think
going.
there's both fascinating examples, and again, we'll be getting into Section 21. I have my own story about Section 21 that we'll be touching on later, and we'll also be looking at and discussing how it's being phased out with the 2 new pieces of legislation that are going through Parliament at the moment in the UK. But no, that's fascinating, and I think it's always interesting to hear how these things affect tenants and how it impacts their lives. And they could be doing everything correctly. They could be following all of the requirements. They could be on time with their bills, with their rent. They can be making sure that they're communicating properly with all of the relevant authorities. But at the end of the day, because some specific procedural thing hasn't been done on the part of the local authority or otherwise, and the records aren't exactly in line with the requirements of the law, then they can be penalised. And I think that's highly unfair. It's one of the things I'd be interested to discuss if it's going to get mopped up and changed in the new pieces of legislation.
Just to dwell for a little bit longer on Section 21, because there is an important point. A painful thing I encountered whilst oftentimes representing tenants who are facing Section 21 was that they knew, and I knew, that Section 21 was on its way out. And that were this possession attempt being brought perhaps 6 months, perhaps a year in the future, there would be no basis for this tenant to be evicted. However, because the law hasn't yet changed, they were still going to suffer this possession attempt. You know, I'd encounter quite lonely elderly gentlemen who perhaps have had quite a quiet life, no family to speak of. You know, they may have retired, and they may be in quite a difficult spot financially, but nonetheless, they've been model tenants, and yet because because the possession attempt is being brought now, these people are being evicted from places they've lived in for decades. Quite distressing on these people. You know, people would express even suicidality as a result of the possession attempts being brought against them. And I just think it's these instances of these beleaguered, kind of vulnerable members of our society that really drive home the essential nature of this abolishment of Section 21. So it can't come soon enough as far as I'm concerned, and it's taking far too long.
Fair enough.
Now, I can speak to a few other instances in the county courts. Within current housing legislation, there are protections for disabled people under the Equality Act. So as long as it's not Section 21 procedure we're talking about, and perhaps it's a Section 8 procedure, a tenant may have a defence to a possession that's brought against them if they have a disability as recognised in the Equality Act. So I had an instance of a tenant who was accused of antisocial behaviour, and you know that there was a long list of things she's alleged to have done, disturbance she's alleged to have caused her neighbours, but this lady was quite disabled. She suffered from epilepsy, post-traumatic stress disorder, depression. Life was really quite tough for her. And this was borne out in real time in my experience, because as I was sat there next to her in Portsmouth County Court with her future housing situation being discussed by the court, she suffered an epileptic fit right there.
In court?
In court.
Wow.
And the proceedings were adjourned because there was a question as to her competency to even receive and understand the proceedings. It was a fit that she suffers regularly, and it's just something that needs to work itself out, and she's fine at the end of it.
Glad to hear.
But I think what this instance shows is that again, it's vulnerable people who are typically facing possession proceedings in county court. And I'm glad in this instance that organisations like the Wiltshire Law Centre exist, such that these people are not left to fend for themselves in legal proceedings, because they don't have the means to appoint counsel themselves. They are entirely reliant on civil legal aid. Again, an instance in the county courts, I had a client who is facing eviction under Ground 8 of the Housing Act. Now, Ground 8 is a mandatory ground, which means if it's met, the judge has to award possession. And that ground was that if the tenant was in 2 months' worth of arrears, automatically the possession will be given, okay? However, in conference before the hearing, the client had said to me that he had the means available to him to actually bring the amount of arrears below this 2-month mandatory threshold. He just needed time. So I made this representation to the judge. The judge agreed to a 2-hour adjournment to test this tenant's theory, because the judge must have heard many such theories before. At which point the tenant told me that whilst he did have the funds available, it was in the form of a cash loan from his family, which he'd need to collect, deposit in his bank, and make the transfer on before the resumption of the hearing. We only had 2 hours. He also told me that he hadn't brought his bank card to court, and so he'd have no way to even deposit the cash, even if he had the cash. So, faced with the clock ticking, and the fact that this tenant did not have the means to purchase a taxi, I offered him a lift on my bicycle,
Wow.
such that we could take him to his house to pick up his bank card. We then cycled our way to Halifax Bank on Commercial Road, Portsmouth, where we met his brother. We took the cash, it was about $2,000, deposited it in Halifax. He then made the bank transfer using his mobile app to the landlord, thereby reducing the amount of arrears below the mandatory 2-month threshold. We then returned to court, receipt of transfer in hand. I made the representation to the judge that we were no longer in the 2-month threshold, at which point the judge agreed to a suspended possession order as opposed to an outright possession order, which was a distinct victory for the client because it was a complete reversal of where he was just 2 hours ago. And I'm proud of that instance because I went above and beyond for my client.
That's a fascinating example that you even gave him a lift on your bike, and you did it all within 2 hours. It's impressive. And then back to the courtroom, and you had to be present in the courtroom within the 2-hour window. It's like a scene from a TV show. Okay, no, that's a fascinating example. Yeah, okay. And presumably that tenant is now in a better position. They've obviously managed to bring the amount they are in arrears below the threshold, and hopefully that story has a happier ending. So,
I did actually have some contact with the client following this hearing, and he was in great spirits, and was convinced that he could become a professional golfer. Actually,
I see.
So I wonder if we'll see him competing with Rory McIlroy.
That would be amazing. I would like to see that. We should follow up with him. That would be great. Okay, good. No, those have been some really fascinating and colourful examples. So I'm grateful to you for sharing those. Okay, I think we can move on to the next question. So in general, both in your personal and professional experience, do you think that property in the UK is good value for money or bad value for money, in particular comparison to Europe, based on your experiences as well, living in Europe?
So I think we have a comparison between the UK and Europe, and we have a comparison between, say, London and the North, and just other parts of the UK as to value for money. I'd say presently I don't feel that I have value for money in terms of my current property. Whilst I love where I live and I'm really happy with my apartment, I'm paying 2/3 of my monthly salary to keep a roof over my head, which just leaves so little in the way of other living expenses, in the way of savings for property in the future that I would aspire to purchase. Just isn't value for money in that sense. If somehow this balance could be readdressed so that I'm paying maybe a third, maybe just half or something, I'd be in a much more comfortable position.
It's not a unique position either. I've discussed that with other people that we've done collaborations with, and in fact even introduced some statistics. So 66% roughly is what you're describing, and that is over and above a number of the recommendations that come from various institutions and governments and organizations and charities, including the ONS, Institute of National Statistics, which state that you shouldn't really be taking it above 40 to 50%, because it does limit people's capacity and flexibility to take on board unforeseen costs that come along, and everybody has those in life. So I do understand and I sympathize with that, and I have been in that situation myself in the past as well, where your outlay is more than 50% of what you're earning, and there's just so little contingency there. Like, it's very hard to make sure that you're covering all of the things you need to do in life, and in some ways you don't then get to enjoy some of the things as well, like holidays and travel. Time you just have to kind of focus on kind of living, eating, and getting by, and obviously that's a stress in itself. That is something that people suffer with. I'm aware of that, particularly in London, as you say, but also elsewhere around the UK and the big cities. I'm acutely aware of that.
It's also, I think, professionally inhibiting for me personally, and I can talk to the barrister career path. You know, the barrister career path, it's one that's notoriously hard to break into. It might be akin to the architect line, although sounded horrendous as well on your side. So what I mean, there's a lot of hoops you need to jump through to become a barrister, and before you've gained the final certification, let's call it, which is called a pupillage, you can't yet practice as a barrister. So until that point, you have to. There's a lot of signalling you need to be able to do to these future employers that you're good enough, and getting that experience to do that signalling is often not well compensated, especially if you're going into legal aid work, which I seem to be drawn to.
Yeah.
And so my point and how this relates to housing is that I'm having to pay levels of rent that are completely out of whack to the type of experience I need to accrue to actually advance professionally. So I've probably got a few years worth of applying for this thing called pupillage before I'm eventually going to have to cut my losses and say, it's not going to work out, I'm going to have to transition to another career. I hope it doesn't come to that, but it could do. These are the pressures that come up with this housing market situation we live in. And just to quickly hark back to the original question, I do think there's just a slightly fairer system in Europe, just in terms of value for money that you get for the rent you pay. And I'd say also my experience living up north, better value for money, perhaps more green space, even for a much lower rent. So yeah, the London housing market is tough.
It's very tough on a lot of people. I do understand and sympathise with that, and I do obviously hope and wish you all the best with the passing of the bar and the ongoing pupillage. I really hope that works out for you. Thank you. Okay, we'll move on to the next question now. Rationalizing things as much as possible based on your personal and professional experience, would you put down the bad experiences to which factor in particular? Would it be the bad landlords? Would it be design? Would it be maintenance? Would it be legislation? Or in some cases, dealing with local authorities? I'm very interested to hear your thoughts on that.
I think from an access to justice perspective, there is a deficit when it comes to tenants' understanding of their rights. If somehow through civic education, PSHE classes, whatever, tenants had a real sense of what it means to have a tenancy agreement and the rights that affords you, they would then be in a far more empowered position to approach dodgy landlords for redress, and failing that, use the legal system for their own advancement. Whereas at the moment, landlords seem to hold all the cards, because not only do they own the property, in my experience, they have a much better sense of the legal landscape, and they have access to the legal support that can help them manipulate the legal system to their advantage. We need tenants to be conscious of their rights in law, conscious of how to access certain defences where possession attempts are illegitimately brought against them, and able to access legal support through organisations like the Wiltshire Law Centre, which are quite exceptional in nature, such that they can resist rogue possession attempts against them. But outside of the legal system, if tenants are just aware of their rights in law, they are much better placed to approach their landlords with a sense of strength and confidence in demanding certain standards for them. But of course, the other things you mentioned, legislation, I do think the Renters' Rights Bill and the Renters' Reform Bill will bring in positive, largely, changes in favour of tenants. And we'll get into the minutiae of that later, I'm sure. Of the things you mentioned, which would stand out to you as a basis for poor housing situations?
From my perspective, it's obviously looking at this as an architect, as a builder, as someone that specialises in property consultation and the kind of construction and development of property. My own experience is that like the standards aren't sufficient, or there are too many separate siloed of standards and guidelines that don't necessarily address all of the things that consumers and users and tenants need. I think there's a kind of exercise to be done there, which is why I'm articulating and calling for and promoting a kind of gold standard for enlightened property. That's what I want to work towards. That's what I'm collaborating with a number of people on. And I think that's one thing that could bring together all these kind of disparate threads and say, this is what will make a good property. That's my experience. But I think there are aspects of that where you can kind of, through design, help to kind of, and through standards, help to factor out the problems that you get later in the building cycle with maintenance and end use. Because if it's well designed from the start and you have those kind of key systems and elements in place, you can then avoid things like black mold, and you can avoid things like tenants having issues with ventilation or lack of lighting, or being exposed to toxins and pollutants, volatile organic compounds being leached from cheap furniture, etc. All of this, which actually in the long term affects people's health. There's another area that I think. But I'm very interested in how that overlaps with legislation. And I think I'd be interested to get into the legislation as well, to see what's in the current bills that are going through Parliament. We're going to touch on that. But what it doesn't do, and then what's missing, and how do we kind of like promote and champion and call for those changes which take it the next step. So it's not just kind of addressing issues with tenants' rights, but also saying, like, should the standards be improved? Should those standards be codified into law? Obviously have things like building standards, but they're a kind of baseline level. They don't deal with the kind of some of the fundamental basics of what makes a good, efficient home, unit, house for people to live in. Does it cover all of the basic criteria, including storage, including access to proper ventilation, as I mentioned, so that people can have a kind of rounded and reasonable tenancy and life in that apartment or house, whatever they're living in, but also whereby they in addition can get something that's good value for money. And the affordability aspect is the other thing that interests me, because you could take all of those examples that I've given and say, we're applying that to property, and it is applied to the luxury property market, but none of that is applied to the affordable housing market. The affordable housing market is generally kind of like a baseline, and a lot of corners are cut and scrimped. So I think there's definitely work that can be done there, in legislation, in standards, in guidelines, that help tie those disparate threads together and lead us to a more enlightened form of property, this kind of gold standard that people would see and they'd recognize that, okay, this property will be good for me, and I won't necessarily be paying over and above the market value for something that's going to make me sick or affect my health or mental health. There's such things as sick building syndrome, which, quality of light, ventilation, mold can affect people's health.
And which does cost the NHS hundreds of millions.
Exactly.
Yeah, I do think from my survey of the 2 renters' bills coming through that at least some of your concerns will be addressed.
Great. Well, let's get on to that right now. Okay, then let's touch on some anecdotes. I can talk about my own personal experience with Section 21. It's a very colourful story, a little bit like some of your tenants that you represented in court. I was renting an apartment in Fulham Parsons Green, myself and one other person. It was a property which was in a good location. It was a fair and reasonable price that we paid. I would say that it was around market value or maybe slightly below market value. So we were getting a good deal. But some of the issues that we had with the property just kept coming up time and time again. Legacy issues, things that I would be flagging to the landlord. Issues such as the roof would be leaking and the water coming in would leak into some of the ceilings and the electrics, which would then go out in one of the bathrooms. That was a problem. We would flag it. Sometimes it would get fixed. A lot of the times it wouldn't. There were examples of extractor fans that didn't work and never worked. Pigeons that would be nesting in the chimney and would come into the apartment. That's a sanitary issue. We had issues with the kitchen, the units in the kitchen not being properly maintained, hadn't been replaced for more than 15 years. There had been various instances of flooding that had then led to mold, all of these things. So there was this long shopping list of issues that I'd been notifying the landlord about, and they kept saying, oh yeah, we'll do something about that, and never did. Instead, what they did a couple of years ago was basically say, we're going to increase your rent. So I said, okay, I'll agree to an increase in the rent, provided you fix the legacy issues in the apartment, which we've been raising for a number of months and years. We would say that that's a fairly reasonable request. We're not denying the increase, but we're saying that we want these things to be fixed so that we feel like we're getting good value for money. In response to that, the landlord did not reply to any of the emails or messages. They simply served a Section 21 notice saying that they wish to take possession of the apartment, and that we had a period of time, which I know was less than 2 months, to get out of the property. And on further kind of fact finding and discussions and negotiations, understood that the reason they wanted to do this is that they considered the improvements, or they called them improvements, they considered fixing the issues to be too cost prohibitive for them to do to us as long-standing tenants with no issues, no faults, never in arrears, simply because it would cost too much for them to fix those problems, and if they were going to fix them, they'd rather redo the apartment, renovate it, and then they could sell it or rent it out at a higher price. So that was the situation that we were faced with. We talked about trying to obtain advice from a solicitor, where we could have argued potentially taking it to court to reject that. But the general consensus, myself and the other person, was this would not be a good investment of time. It would be potentially quite costly. It could potentially drag out. They might eventually find in our favor, but ultimately we knew that we wouldn't be staying in this property long term, so it was better to kind of cut your losses and run, so to speak. And so I was more inclined to fight it, but the other person was not, and they simply wanted to get their deposit back, and the landlord hadn't put their deposit into a protected scheme as required. The landlord had that in their own personal account, and so that was a kind of like lever of power that they had over that particular tenant to kind of force them to sign up to and agree to getting out of the property in that time. So that was a stressful experience, but what I'd be interested to hear is, very briefly your thoughts on that and how our situation might have been improved by some of the changes that are now going to come through with the new legislation.
I think I'm right in saying that your landlord's failure to protect your deposit actually precludes your landlord from resorting to the Section 21 procedure. I think I'm right in saying that, although I need to double check that. And to me, that just shows that a lot of this is about tenant awareness of their rights. You know, had you been aware of the fact that the Section 21 procedure was not available to the landlord in this case, absolutely not available, perhaps you would have been that bit more empowered to actually fight the possession attempt. What I'd also say is that this is an example of, I would say, an effective retaliatory eviction attempt, even though it's not a literal retaliatory eviction attempt. It's effective in the sense that you've reported disrepair, and your landlord has engaged with your reporting of that by serving you with this no-fault eviction attempt, okay? But it's not a literal retaliatory eviction situation because, as referencing the previous tale, the landlord had been served no improvement notice. So that's just an example of how brutal the Section 21 procedure was. But on the other hand, you could say that maybe to an extent the system was working as it is supposed to, because you and your housemate made a cost-benefit assessment and decided that you were better off kind of cutting your losses and moving on to a new residence rather than fighting this in the courts. And to an extent, that's how things should be. Not every dispute needs to be litigated in the courts. And that's actually addressed in the new legislation because there's going to be a new ombudsman created.
Okay,
and the idea with that is that a lot of sort of landlord-tenant disputes can actually be litigated, quote unquote, in non-court ways. And that'll be a time and cost-saving measure.
I think that's very interesting, and I think people also respond well to this idea of an ombudsman, like an independent party that you can go to. It's meant to be impartial, and it's meant to look at these things without it having to escalate all the way to a court. I think people will actually respond quite well to that. I think it could be a positive development.
Because say in your scenario, your housemate had considered the amount of time he'd have to put into the court system and probably thought, it's not worth it. But if it was a more accessible ombudsman with a more chilled out dispute resolution process, perhaps his decision would have been different. And as such, there might have ended up being a bit more of a just settlement for all parties actually in that dispute.
Yeah. Okay. No, that's really interesting. Thank you for sharing that. So, as it stands, there are two major pieces of legislation going through the UK Parliament right now: the Renters Reform Bill and the Renters Rights Bill. I'm very interested to hear specifically your thoughts on these two bills, what they will change, and also, in your opinion, what might be missing. I think that would be a very interesting thing to hear.
The question you've all been waiting for.
With bated breath.
So yes, there are these two key pieces of legislation specifically targeted at the rental sector, which has expanded massively since 2002, say. And this is set out in the policy context of the legislation, which you can find on the government website. Tenants now make up, I think, 19% of the housing market in the UK, 11 million people, okay? So it's a really important element of the UK's housing market, and as such, it's important this legislation is done correctly and thoroughly. And I think because of the wide-ranging effect of these pieces of legislation, that in part explains the quite severe delay we've seen with actually the passage of the legislation. So take the Renters Reform Bill. First reading of this bill in the House of Commons took place on 17th of May 2023, okay? So we're approaching 2 years since that first reading. Legislation is still yet to pass, although it's in the Lords. And I just think because of the importance of this area, that's why it's being done so thoroughly, okay? Now, I'll first talk about the Renters Reform Bill. I'll then talk about the Renters Rights Bill, okay? Because there are interesting, possibly subtle distinctions. Okay, Renters Reform Bill, sponsored by Michael Gove, who was previously the Levelling Up Secretary. At that time, the headline grabbing element is that there's an abolishment of Section 21. Okay.
Hip, hip, hooray.
Hip, hip, hooray. Tenants across the land can sleep easier in their beds for knowing that they cannot be evicted on a no-fault basis. Just, I think, an essential reform, a straightforward reform. If you enter into a legal contract with your landlord in the form of a tenancy agreement, why should it ever be the case that you can be evicted simply according to the landlord's whim? Of course, there should be clearly stated legal bases as to how the landlord can evict you, and the landlord does have protections themselves. But on a no-fault basis, it's unjust for all the reasons we've mentioned in our discussion, and so I'm really happy to see the end of that. As mentioned, there will be the creation of an ombudsman, which will be able to preside over, I imagine, certain low-level disputes between landlords and tenants, and that will be an effort to declog the county courts, which at the moment, for some courts such as Portsmouth, on a weekly basis, they have possession lists where you have scores and scores of possession cases, taking a lot of district judge time and sitting hours, and that's time that could be better spent, say, in family disputes, childcare matters, or more serious, higher value property-based disputes. And so the more work that can be taken out of the purview of the court and put into the ombudsman, the better the whole system will be for it, I'd say. So I think that will be a welcome reform. There is a decent homes standard that is going to be introduced by this Renters Reform Bill. And this decent home standard will require that landlords register themselves and their property to a kind of online database, and this will be available to tenants when they are deciding how and where to enter the rental market to assess the quality of the housing that they're set to enter into, the past record of this property, perhaps renovations that have been done over time. I think this decent home standard will address some of the concerns you set out previously, but until we see it in action, it's hard to comment. There are, in this Renters Reform Bill, certain provisions that are more landlord-friendly. And I just want to say I'm not, per se, anti-landlord.
No, nor am I. I mean, I'm interested in a kind of fair shake and a fair system, and I think there's opportunities for everyone to get involved in this and to improve the situation for all involved. Property Enlightenment is about attaining a kind of enlightened state for tenants, but also for landlords and house builders and everybody to try and find better efficiencies.
Because it's important to say there are some excellent landlords across the country, people who take pride in respecting their tenants' rights and diligently observing their duties as a landlord and responding to disrepair complaints and such.
It's true.
In fact, these are possibly a majority of landlords in terms of the private sector across the UK. So we should never demonize landlords. That's not the intention. However, with the loss of the Section 21 procedure, that's an important quiver to the
Arsenal.
Quiver to the arsenal.
Quiver to the bow, yeah.
Quiver to the bow of landlords that is now lost, okay, because landlords can no longer, on a no-fault basis, evict. And so landlords' ability to take possession of property through other means is actually strengthened by this Renters Reform Bill. One such way landlords rights are being strengthened is on the matter of antisocial behaviour, attempts. Landlords, if they are able to show that tenant behaviour would be likely to or could cause nuisance or annoyance to neighbours, say, will be able to, on a discretionary basis from the judge, take possession of property, okay? So just to try and put that in slightly less technical jargon, landlords will have an easier time in their attempts to evict tenants who are displaying antisocial behaviour, okay? And I would probably lean towards being critical of that because, as mentioned from my county court experience, sometimes what is perceived as antisocial behaviour comes as a result of disabilities that tenants are suffering. And so the balance between tenants' rights under the Equality Act not to be discriminated against because of their disability, coupled with landlords' rights to take possession on the basis of antisocial behaviour, that there needs to be a delicate balance here. And that balance will be hopefully found by the district judges who will be adjudicating on these possession attempts. But I'm just keen that we don't see a sort of renewed assault on disabled tenants as a result of this reform. Okay. Other slightly interesting elements are that there will be a particular provision for student lets. If a rental situation is deemed to be a student let, rented out to a student on an academic year basis, the landlord will have a mandatory right to reclaim the property at the expiry of the academic year, as long as they comply with the possession paperwork requirements, okay? I can see there may be friction arising here where perhaps a landlord, because they can't evict through Section 21, tries to use this student-let procedure to evict, and a student resists that, and I can see litigation arising on that front. But I think at the heart of this reform bill, which, let's state, is sponsored by a Conservative, is an aim to, on the one hand, protect tenants, but on the other hand, not scare landlords that this is a landlord hostile environment, okay? That's the thrust of this reform bill. I actually think the subtle nuance I mentioned in terms of the difference between the bills is that the Renters' Rights Bill is far more tenant-friendly in its approach and actually a bit more willing to go in on landlord malpractice than this reform bill. I think this reform bill is trying to please both sides in its work. Another reform we see in the reform bill, as well as the rights bill, okay, commonality, is blanket bans, okay? So currently, an end to blanket bans. So currently, some landlords will have a policy that they won't rent out their property to people who have children, say, and they won't rent out a property to someone whose income is partially or wholly derived from benefits, say. That, going forward, will be discriminatory and illegal, okay? And I think that's a positive reform because families need support in securing good quality accommodation and should not be discriminated against for having had children, especially as we live in an aging society with low birth rates. You know, we need to kind of encourage and support families as they seek to enter the housing market and ascend it. And on the benefits point, people can be claiming benefits for any number of reasons. They should not be stigmatized for doing so. It may be a stopgap measure for them. It may be a long-term thing for them. To me, it would seem straightforward that a landlord cannot discriminate on that basis, okay? As long as the landlord is satisfied they'll be paid the rent, and it's fair enough to do financial checks, they ought to award the tenancy to the prospective tenant. So that's a little bit of a review of the Renters Reform Bill. It's currently in the second Lords reading. Okay, so still to come, we've got committee stage in the Lords, the report stage, and then the third reading in the Lords. Finally, there's a final moment where amendments can be proposed between both houses, and then royal assent. Okay, so not too far away on this bill. We're approaching the 2-year mark. You'd hope that within 2.5 years, this legislation is passed. Because as mentioned, you've still got people in county courts across the country being evicted under Section 21.
Which is still active.
Which is still active. And that's a manifest injustice, I would say.
Okay.
So that's the Reform Bill. I could move on to the Rights Bill. So the Renters' Rights Bill, sponsored by Angela Rayner. Okay? Quite a fiery character. Part of the Labour Party. And I think that is part of the reason why the flavour of this bill is that bit more pro-tenant and anti-landlord than the Reform Bill. And Angela Rayner is the current housing minister in the UK. So this was introduced 11th of September last year.
After the change in government.
After the change in government in July. And it's currently at the committee stage in the Lords. So this bill repeats the abolishment of Section 21, but it has a few additional items which I think are interesting. There is a ban following the passage of this legislation on rental bidding. So a landlord will have to publish the asking rental amount, and this will be a fixed amount. What the landlord cannot do henceforth is to curry the interest of a set of prospective tenants and get them to outbid each other.
In a
so
bidding
the landlord,
war. Yeah.
Pardon?
In a bidding war to
In a
avoid
bidding
a
war.
bidding war and competition.
Yeah,
That's fair.
this bidding war will be a thing no more. That seems like a positive reform to me. I don't really see a downside on that. There's also a market rent provision. Okay, so where a landlord wishes to boost rent, they must give 2 months' notice. There's a certain form they must present to the tenant, but this rental increase must be at market rate. Okay, and I don't know exactly how that market rate is known or discovered, but there'll be some kind of reference point for that. And where this rental increase is above the market rate, the tenant will be able to appeal this rental increase, whether that's to the ombudsman or to through the county court process, I'm not sure. But that seems, again, to be a fair enough measure. Landlords, I don't think, should have unmitigated power to boost rent as and when they please. There should be a curbed power, and it should be proportionate to market increases, okay? I don't think the rental sector should be a place where landlords can simply extract as much value from their tenants as they see fit. So this is a redress in favour of tenants, and it's one I support. Whilst this legislation also mentions the decent home standard, there's also going to be a private rented sector database. So across these legislation, we have the decent home standard, the private rented sector database. I suspect these will end up merging somewhat. They seem to be covering similar ground. It's about encouraging transparency and boosting tenant access to available options when they're considering how to enter the rental market. In county courts previously, it was the case that 2 weeks' notice on a Section 8 possession attempt would be sufficient. That's being expanded to 4 weeks. Okay, so just a small example of how tenants' rights are being boosted by this legislation. Now, there's much more to say about this bill, but hopefully I've covered.
No, I think you've captured a lot of really good material there. And it's very interesting. Thank you for going into the nuanced detail as well, the minutiae. One thing that I think you brought up as well that I'm very interested in was this kind of positive design standard. How was the exact wording that they put in the bill?
Decent home standard.
Decent home standard, which I'm very interested to look into further. I'd heard of it, but I didn't know much about it. And so obviously my own interest in kind of creating a gold standard is to look at what that does and what that doesn't do, and then what's missing. And obviously, every piece of legislation that's introduced looks to fix some problems, but it doesn't always fix everything. So there's always things evolving and changing and that need, further work, further legislation later down the line, and or changes in design standards and guidance and building standards. And so I think there's an area of further research for myself there. I'd like to get into that. And I think looking at that, and then in terms of the collaboration that I'm doing on the gold standard, to make sure that the two of them are aligned, and that we also take the gold standard forward so that it does the things that the other does not. I think that's going to be a very interesting area of development. So 20 years ago, in 2005 in London, the average house cost 7 times a person's salary. Now that has risen to 13, 14, 15 times their salary. Homes have shot up 130+% in value. And a lot of that has been felt quite acutely by people who are looking to purchase homes, but then also it gets passed down to those renters as well, tenants, because obviously the costs of mortgages are so prohibitive. One of the factors feeding into this as well is the kind of evaporation of affordable housing. So between 2022 and 2023, the government obviously has affordability targets. Local government does and national government does. And in London, in that period, 22 to 23, there were only 35,000 affordable units that were built in London, which is down by 88% on the previous year, and it's attaining only 33% of the local government's goal and national government's goal for London. So you can see there, you're in a situation where we have this very hyper-competitive market, where people are struggling to get onto the housing ladder, to obtain tenancies, and then add into the mix you have government failing to meet its own targets, failing to deliver that. And the reason they're failing to do that is because, and I can speak to this from my own experience, there have been cases where there are developers who have chosen not to include any affordable housing in their developments. So there are obviously requirements for every development to include a percentage, usually 25% of social housing, affordable housing, and they just opt out from doing that. How can they opt out of doing that? It's a question that a lot of people struggle with. Essentially, you can try and negotiate with the local government, which they do, and they say that it's not commercially viable, that they can't afford it, that it makes the build too expensive, etc., etc. There might be a payment that they make to the local councils. They'll pay the local council the value rather than building the houses, because it's actually cheaper to make a small lump payment than it is to invest in all of the other things involved in building the homes. But what does that mean? That means that that money goes to the local council. That local council is obviously, in the instances like some of the local councils in London or Birmingham City Council, for instance, which is not bankrupt but has gone into a form of bankruptcy. That money then is redirected to other priorities, and it never makes its way into affordable housing. And so there's a failure to deliver it. There's a failure for people to be able to attain it. There are shortages of it. And I think all of this is just compounding the problem. I'd be very interested to hear your thoughts, because we've touched on social housing and council housing. If you've dealt with any of that in your legal work, with the Wiltshire Law Centre and in Portsmouth and in county courts as well, whereby there are people that have struggled to obtain affordable housing, and therefore they're pushed into private rented accommodation, and that rented accommodation they then might struggle with because it's more variable, there are higher costs, and as a result, someone who's, for instance, an ambulant or disabled person might find themselves without access to what they need, and they might then be put into or encouraged into a private rented situation.
Certainly, there have been numerous instances of clients starved of opportunities to obtain council housing, forced into the private sector that they can't afford, and that is unequipped to actually deal with their problems in terms of disability and affordability. So yeah, I'd say that's a very common story. People waiting years and years on council housing waiting lists to no avail. I hope that with the planning reforms that we see from this government, and it seems a renewed emphasis on house building, that supply of homes will increase substantially. But
I think the targets are there, but what that needs to be followed up with is the kind of policing of those targets. Are they actually going to meet them, or are they just going to allow the situation that we've been in, the kind of laissez-faire approach of the last 10 years to continue, plus maybe more?
well, hopefully the planning reform will address some of that. I haven't looked at the legislation, but hopefully that can expedite house building somewhat.
Yeah, I hope so. And I think it's something that obviously we're keen on developing and working on as part of Property Enlightenment as well. This focus on finding affordable housing solutions for those key workers, for those paramedics, nurses, etc., as part of the mix, including not just private rented accommodation, but also affordable housing, potentially for social housing as well. And I think to assist with that, there is a need for it. There are targets for it. There's money there. But it's just, for various reasons, not being delivered. And I think that's an area of missed opportunity that I think that Property Enlightenment could in part help with and develop and fill. But yeah, I think that's going to be an interesting roller coaster to be on. I have no doubts about that, because it's obviously an area of much more stringent legislation compared with private. But I still think it's a worthwhile mission. So I'm very interested to get into that as well. Are we in need of an enlightenment or a renaissance in the world of property to lift us out of this predicament? And if I say the phrase property enlightenment, what does that mean to you?
I think we are in need of a realignment that this phrase suggests. I think if there can be a product of Property Enlightenment, I'd like it to be something of a restoration of dignity to perhaps tenants and landlords alike, but of course I speak more to the tenant perspective. Dignity in the sense that tenants can reasonably believe that through their salary, which could be a median salary, say, they will be able to afford housing that they are really proud of, that they're really proud to live in the area they do. They're proud to invite their family and friends to see the house they've gained on the salary they're on. They have a good relationship with their landlord, perhaps. I mean, it won't
Hopefully.
always be the case, because it would drive lawyers like me out of business if it was. But a relationship between these two groups that is cordial and collaborative at times, where both sides understand their rights and privileges. And I think part of that dignity will be in the value for money. If tenants can spend far less of their income on housing that they are nonetheless really proud to live in, they'll have that much more money to invest in their local community and then their life at large, such that we will see downstream benefits to an increase in affordability of housing.
Massive. There are so many, and I've touched on this in other collaborations and work. You can go through things like birth rate. You can go through things like marriage, settling down, having families. You can go through things like mental health, physical health. You can go through kind of security, sense of ownership, belonging. And then all of those things also feed into the economic picture. Like, for instance, the fact that the birth rate is the property is affecting the birth rate will also then have an impact on the economy in future, because People are settling down later because they can't get affordable property. If they can't get affordable property, then they aren't getting married as early, they aren't having children as early. All of this in 20 years' time is going to have an impact on the number of workers in the system paying taxes. It's going to have an impact on the workforce. So I see the kind of micro and macro scales of this. And I'm glad you touched on those points. I think there's a kind of point to be made there about how we can address those issues so that we kind of move to a more enlightened state where people have that security. They feel like they're getting an affordable house or apartment or unit. They can get the better sense of ownership and belonging and security. And then also they can kind of cool the flames and tempers of a lot of the issues that you brought up, like a lot of the stuff that's going through the county courts, where there are just so many people who, for various reasons, are battling with their landlords, to try and cool the temperature of all of that by offering people a better product to start with. I think that's, for me, the core of property enlightenment. And I'm glad that you mentioned some of those points. Yeah, I'd be interested to see how we could look to work with politics and campaigns and persuasion on bringing landlords along on that journey as well, and making sure that they feel included in the process.
I'd also like to add, as to my sense of property enlightenment, that perhaps we need a recalibration away from what has been the status quo since, I think, the time of Thatcher, which has been that we live in something of a property-owning democracy, where the ultimate aspiration really has been to buy a freehold of your own, that you can call your castle. Because what we saw with the right to buy scheme, people purchasing their council homes, we saw, I think, as a result, a stigmatization of living in council housing, and that stigmatization, I think, is an unenlightened state, I would say. I think we ought as a society to become comfortable with the idea of council housing, the idea that you pay a subsidized market rent, and yes, you may not own the bricks and mortar of your property, but nonetheless, through the affordability of the property, through hopefully the quality of the property, which could be boosted, you have dignity and you have sufficient resources to live a fulfilled life at large and aside from your residence in this property. So I think if we can recalibrate our property aspirations such that there are different ways to be living well and to be proud of the property you live in, I think that would be an enlightened property state.
I agree. And I can take one point actually there. I did a first aid course recently, which I enjoyed very much. I wanted to do it. I wanted to be able to have that knowledge if I'm ever in a situation where I need to help someone. I think it's important to be able to do that. That would be the worst thing if you found yourself in that situation and you weren't able to help a person. And as part of that course, I actually had an opportunity to meet a number of paramedics. And paramedics in London, in particular, but even outside of London, have issues with housing. And obviously they're a key worker, so they're on the lists for availability. They are able to more easily get hold of and to apply for social housing, council housing, key worker, as a key worker, and affordable housing. And they are so important to the kind of functioning of the health service as well, moving people from sites of casualties to hospitals, providing treatment, keeping them alive, dealing a lot with older people as well. And the paramedic that was providing the course explained to me that the ceiling to which he can earn in London is £32,000, which precluded him from living in London. So he travels out to Chesham at the end of the Metropolitan line, and then travels into London every day from Chesham for almost 2 hours each way, just in order to work in London and to provide the critical job of a paramedic in London. Now, he does some training days and he does nights and days in the ambulance as well. But those key workers on £32,000 are obviously not able to afford apartments and houses in London. They have to go out, and even then, it's still a struggle. He said that outside of London, I think the kind of ceiling was 27,000 or around there. So again, they also have their own struggles. Those workers should have access to affordable accommodation that meets their needs for dignity and security and all of those things, because we need them to do the job that they're doing. They're critical workers. And so one of the things I want Property Enlightenment to do is to provide solutions for that. So ultimately to kind of like articulate the standards for that, and then ultimately to try and build those units and offer those to key workers as well. So a fraction or a percentage of that will be for key workers like paramedics and nurses and others who are essential to the safe functioning of society. And I think the examples and the discussion that you just raised reminded me of that, and that's why I thought I would bring it up.
Yeah, I think that example is good because it touches on different problems in society. It touches on perhaps the inadequate compensation accrued by some of society's most essential workers, married with the sheer unaffordability of property that exists in the space where they actually work. So they are having to make a time sacrifice to go on the outskirts, and not only a time sacrifice, but an energy sacrifice, because a long commute is quite tiring, actually. And as a result of that, they're kind of less prepared, less able to work than they would be, say, if they had a property more close to their work, An obvious point, but this speaks again to the kind of downstream unfortunate consequences of just the unaffordability of property.
The housing crisis.
Yeah.
Okay, that was really good. What, in your opinion, personal and professional, would be the next steps that we need to take for property enlightenment and to try to attain that standard? What would be the kind of what's the roadmap? What are the critical points along the way that you see from a legal perspective as well as your own?
So when we first met, you used a phrase that I found quite compelling. Outrage activation. I think that's important. And outrage activation is not about shouting and jumping up and down. It's about activating awareness amongst tenants in particular as to the injustice of the present moment, and I think scoping out the way society could be. Okay, were property to be more affordable, of a better quality. So it's identifying the present problem, looking at future solutions, and it's looking at future solutions with reference to legislative developments that we've discussed, with reference to other property situations around the UK as well as in Europe and comparable economies. These are all useful reference points in scoping out the way society could look were reforms to come about in housing. So there's that vision building that I think is important to property enlightenment. Then you have the meat and gravy of this, which is continuing with podcasts such as this, getting a variety of stakeholders. So say I've been able to bring something of a legal perspective. Perhaps if you were able to bring in a paramedic, say, to talk about their kind of commute experience and to kind of put flesh to the injustice of that, I think that would be quite compelling to the audience.
Like a testimonial.
Testimonial, yeah. Maybe a fellow architect.
I have plenty of long-suffering architect friends, yeah.
Yeah. Maybe someone who's more, say, explicitly political than I am, someone who's invested in this politically right now, maybe someone who's involved in this legislation in whatever capacity in the Lords or in the Commons. That's an interesting perspective. Of course, also, I think there'd be numerous landlords who'd be interested to talk to you, who'd be quite sympathetic to the aim of this group, and that would be a valuable perspective to bring as well. So yeah, there's lots you can do in the podcast space, and that, you know, through the services of my dear brother, can hopefully be clipped up and broadcast, and thus that feeds the outrage activation as well. I'd love to see some public discussions, rallies, demonstrations, probably more roundtable discussion vibe, which are free and widely marketed. And again, it plays into the outrage activation. But say if you have a panel...
or a street event.
Or a street event where you have, you know, an architect, you have, say, a politician, you have, say, a lawyer, you have, say, a struggling tenant, and they give a compelling account of the struggles of living as a tenant in the UK right now, that the audience in turn can resonate with. That's a powerful community building exercise.
I agree.
And the networking that takes place kind of on the periphery of those events can also lend itself to future collaborations and developments. And I think it's about identifying elements of the upcoming legislation and where property enlightenment can feed into that, such as with the Decent Homes Standard. Is there a way lobbying can be done as to what that standard should look like?
Or how it evolves. I think it needs to evolve. It can't just be a static thing. One of the issues that you had with Grenfell was that the legislation was behind. So in other countries, it had moved forward leaps and bounds, and the UK had held back for a number of years. Had those legislative developments in building standards and fire safety matched those that you found in Germany, the Netherlands, other countries, Australia, etc., there is a scenario that you could describe where Grenfell may not have taken place because that product would have been illegal. So I think there's always this question of continually evolving and developing and improving, and I see very much that property enlightenment can feed into that. This is why I mentioned the better housing standard. What did you call it again?
Decent Homes Standard?
Decent Homes Standard. To take that forward, look at that, explore that in more detail, and to try and like work together with politicians and government on trying to raise awareness and improve it at the same time, so it can become a kind of virtuous circle. Yeah, I agree. I think that's a good point. Yeah. And finally, what is your own property goal? How close are you to attaining it? What's standing in your way? What is the market not offering you? And your thoughts on all of that.
So having decried the move towards a property owning democracy under Thatcher, it would be hypocritical, or it feels a bit hypocritical to say that probably my aspiration now would be to one day own a home. I'm just going to own that hypocrisy and say that probably is.
Everyone has those in life, I think. Yeah.
That probably is the case, that one day it would be nice to own a property. However, that day feels very far away, I'd say.
Even more so in London than maybe it did in other cities.
Yeah, certainly. Where I am now, that feels like a decade away, minimum, which maybe is a bit hard to say. I very much combine my property aspirations with my career aspirations. It's all intermingled. So should I be called to the bar? Should I attain pupillage and then hopefully embark on a career at the criminal bar? Eventually, the compensation this would yield would be pretty decent. In the initial years of practice.
One would hope.
In the initial years of practice, it won't be incredible cash, but with time, it can be pretty decent cash at the criminal bar, and that would give me the platform to get a property of my own. But I also attach notions of property owning to my romantic fortunes, and I'm hoping to meet someone and settle down and raise a family, and depending on their financial situation as well, my property aspirations may maybe accelerated somewhat if we
I can imagine.
combine our market stake.
Yeah, go full medieval.
I'm not close to the idea of, say, a lease situation or even, say, a renting situation. It's location. It's so contextual. I'm not someone for whom owning my own property is the be all and end all, the absolute aspiration. It's something I'm certainly interested in, but I'm open to other kind of property dwelling models as to what I can aspire towards.
I think there's actually a lot happening in that sector now with things like shared facilities in a kind of co-living environments, in the sense that you have your unit, but you have a lot of shared amenities. So you might have your own small apartment, but then your shared laundry facility, kind of shared TV situation. These are quite common in student environments, the kind of like student dorm style, they're also provided by private companies like Urban Nest. But also increasingly there are private sector developments taking on this model and exploring it. And it does offer some affordability benefits because you're kind of taking out some of those kind of quite spacious and quite costly in terms of square footage, which then reflects in your rent, and taking that out and making that communal. So then your gym, your TV room, your kind of dining spaces, if you want, these can all be like booked and used, but you have your own small like studio or one bed apartment, which is as a more basic level, but you have the access to the communal as well. So there's one interesting area of development, and I'm doing some collaborations with some people that provide that kind of model in Luxembourg, in Europe, and also increasingly in the UK. So that's one area. And then also looking at other models, like how that could be done on a smaller scale with houses of multiple occupancy, et cetera, et cetera. So I think that's very interesting. But I want to come back to the initial question, which is what is that dream house? Is it 1 bedroom, 2 bedroom? Does it depend entirely on or do you have a kind of vision in mind of how many children you're going to have, if there's going to be a garden?
I typically say 6 kids, and
6?
I always get
That's impressive.
bemused responses to that. I'd say I'm open to biological children as well as adoption, as a means of achieving this big family aim. In terms of the actual nature of this dream house, when I was working as a criminal paralegal, I was working on a VAT fraud case at Southwark Crown Court, and one of the barristers on the prosecution side on that case I became quite friendly with, and he showed me a house he'd recently purchased with his wife, and it was in Essex actually, but it was in kind of rural Essex, and he had a fantastic garden with a lovely patio and willow trees and I think a little river, and you know it wasn't a mansion, say, but it was a big unit. This house, you know, it was a proper
better value for money.
Yeah, a proper plot of land, and he was there with his wife and their 2 daughters, I think, and it seemed quite idyllic. And I think he had a train that took him into London within an hour, say, which is...
So you're being seduced by the rural life, the commuter life, potentially. Okay,
I was seduced by the picture he showed me and the idea of it.
Sounds very romantic.
I've never been a rural dweller, but I think with age and with time, one might come to be weary of the busyness of metropolitan lifestyle. So I could see that appealing later in life.
Oh, I can understand that. Well, great. This has been an amazing experience. Thank you so much for joining us. I'm really grateful to you for that. And hopefully we can continue the collaboration with a lot of the things we've discussed on changes in legislation, the standards. It'd be great to get your input on that as we go forward. So thanks so much for joining us, Peter.
Thanks for having me.
Hi guys, thanks so much for watching this episode. I hope you found it informative. I hope you found it relevant. I hope you found it interesting. But please don't forget to like and subscribe so that we can continue to grow this movement and work on further collaborations like I have with my friend Peter Jacobs here, among others. If you'd like any further information on me, on my platform, or on Peter, then please check out my website, www.propertyenlightenment.com, or check out the links below. There will be further information, content, and things to follow coming soon. All right, see you guys.